In the previous lecture, we talked about one of the key areas of congressional power in U.S. foreign policy being budgetary power. In this lecture, we're going to talk about the other very influential and key area of Congress's power in U.S. foreign policy, and that is their lawmaking power. What can Congress do in order to influence U.S. foreign policy using their constitutionally mandated lawmaking power? Well, one, they can create new agencies. And in the creation of new agencies, they set up their structures, they set up their rules, their priorities, their policies, and help to shape then what that agency may do. We have the very recent example, our most recently added cabinet level bureaucracy, the Department of Homeland Security, has to deal with elements of foreign policy. And so, in creating that agency and having immigration services under it, border control under it, the Coast Guard under it, you see then elements of national security and our dealings in foreign policy falling under the policies, the rules, the regulations of that organization that was created by Congress. Another way that Congress can and does influence foreign policy using its lawmaking power And so I have here on several different slides a few examples of laws throughout the past century that have spoken to the desire of Congress to try to influence foreign policy. In the 1950s, there were a series of amendments referred to as the Bricker Amendments that sought to challenge the executive agreement and executive order powers of the president. Any treaty that infringes on the rights of U.S. citizens would be deemed unconstitutional. And it's meant to outweigh those Supreme Court cases that we discussed in our presidential section, Missouri versus Holland, Belmont versus Pink, or excuse me, U.S. versus Belmont, U.S. versus Pink. Well, if you'll remember, those had to do with executive agreement and executive order and treaty-making powers of the president. And so Congress wanted a larger say, wanted more power in stopping self-executing treaties. Oftentimes treaties are made in one decade and executed in the next decade, and they are pushed off into the future for enactment, so then the direct consequences of treaties don't have to be felt in an immediate sense, that you can prepare for any problems that may arise. The self-executing part of that is that oftentimes treaties have built-in triggers where once a milestone is reached, it implements a new series of policies or laws. And this would have allowed Congress to be involved in oversight and determining whether or not to accept a treaty and new policies at every step of the process, and sort of disallow this self-executing type of treaty. This is, for instance, one of the controversies that was playing out in the most recent trade treaty, the TPP fight between Congress and President Obama. The Bricker Amendments didn't pass, but this is an example of an attempt to curb presidential powers in foreign policy. One that did pass and was influential is the Case-Zablocki Act. And this is passing a law that requires the executive branch to report to Congress. And this one was specifically on international agreements. And so then if executive agreements are replacing formal Senate ratified treaties as our interactions with other nation states, then recognizing that trend, Congress wanted to keep their oversight, keep their power, keep their say and influence in these areas. And so this requires the executive branch to report all international agreements to Congress within 60 days of entering into force. This was amended in 1977 to include all agreements to the State Department within 20 days of them being made, not of them going into force, and then reporting them to Congress. Well, then, this allows Congress to debate and deliberate these, to raise them to the media, to raise them to the public, to try to sort of sway or influence these executive agreements from going forward, or amend the executive agreements as they go forward. The point is that Congress wants to retain its power, its influence in this trend of executive agreements replacing formal Senate ratified treaties. And this is one instance where they tried to do so. A key piece of legislation that deals with the constitutional powers of the president and the constitutional powers of the Congress in foreign policy was the War Powers Resolution of 1973. This was passed during the Nixon administration in reaction to the excesses of the Vietnam War, the unpopularity of the Vietnam War, and the fact that outside of the constraints of the Gulf of Tonkin resolution, which allowed for activity in Vietnam, military activity, The Nixon administration went on then to bomb, without Congress knowing it, Laos and Cambodia, and extend then its power and extend then our military operations broader into Southeast Asia. And so there was a desire to rein in the president's power to do that. And so the War Powers Resolution was passed by Congress in 1973, vetoed by President Nixon, and in a rare act of congressional power, they voted and overrode the veto of President Nixon. So the War Powers Resolution applies to the use of military or armed force only. A declaration of war, specific statutory authorization, and in the cases of national emergencies, you have to have congressional authority. The president shall consult with Congress. That is, there has to be this reporting on all activities, particularly those that may go outside of an original declaration of war or an original specific statutory authorization for the use of force, what we now call an AUMF, authorization for the use of military force. The president must report to the Speaker of House within 48 hours of the deployment of troops. The president can use force or deploy troops for 60 days without congressional approval, but there's a clause there that if we look at the War Powers Act and the compliance, the reporting that was required of it, you see then that different presidents have complied or not with the War Powers Resolution. And this is the number of reporting or compliance activities. You see at its height during the Clinton administration, they were the ones that complied with it the most. Well, you could say the activities in Somalia, the enforcement of the no-fly zone in Iraq during the 1990s, our engagement in Kosovo and in Bosnia during the 1990s may account for all that. The Bush administration had the authorization for the use of military force in Iraq, and so therefore even though we were more heavily engaged in Afghanistan and Iraq during this time, the compliance or the notifications number would have dropped. But historically, we have also seen the failure to comply where presidents did not notify the speaker, did not notify the Congress, may have had troops or introduced troops in non-compliance with the War Powers Act. During the Nixon administration, there was a military involvement where U.S. citizens were evacuated from Cyprus during the Turkish invasion there. Carter used the military to move people from conflict in Zaire. During the Reagan administration, there was the involvement in El Salvador and in other Central American states outside of congressional approval, and this had to do with the Nicaraguan Contras, so on and so forth, that led to the Iran-Contra situation. The bombing in Libya and in Lebanon during the 80s. The first President Bush sent military advisors to Colombia, Bolivia, and Peru, technically outside of the War Powers Act. Those troops stayed there much longer. If we look at the current president, we see then the exercise of military force without congressional approval in Libya, but also currently, and this is one of the debates of the deliberations, this is the basis of your discussion question. Currently, in our military activities in Syria and Iraq while fighting ISIS, there has not been a new authorization for the use of military force. We were or began to fight ISIS in the middle of 2014, more actively in bombing campaigns, and it's been at least 2 years or almost 2 years without a authorization for the use of military force. And so this is the basis of your discussion question for this section. Does this comply with the Constitution? Does it comply with the Commander-in-Chief policies? Is it unconstitutional because there's not a declaration of war or other specific statutory authorization? How does the War Powers Act speak to this? And so there's an additional reading with your discussion question that can speak to that. A couple of other pieces of legislation that have been important. The Nelson-Bingham Amendment to the 1974 Foreign Assistance Act. Congress can take 20 days to review arms sales. This has to do with executive agreements and treaty-making powers, executive orders as well. Congress wants more oversight in who we sell arms to, who we give military assistance to. They expanded the power in 1976 for themselves to reject arms sales to specific nation states. And one amendment that went along with that is to not sell arms to any nation state that is engaged in consistent patterns of gross violations of internationally recognized human rights. Well, if you read that statement, you see perhaps that there's a lot of leeway there. There's a lot of vagueness in that. Internationally recognized violations of human rights, what's that mean? What is gross violations versus just plain old violations? Does it have to be a consistent pattern? Can it be once? This gives Congress a lot of leeway to get involved in rejecting arms sales when and where it wants to based on this amendment. Another one, the Jackson-Vanik Amendment to the Trade Act of 1974. This is based on the Congress's constitutional powers to regulate trade and commerce, having to do with extending favorable trade conditions known as the most favored nation status to particular nation states. And in this one targeted the Soviet Union. The Soviet Union taxed immigration, that is people leaving their nation state. This is a common practice of a lot of countries. In order to leave, you have to pay a tax or have a certain amount of money in a bank account in your home nation state. And so then, in a way to punish those nation states that we may see as foes, as violators of human rights, so on and so forth, we have this ability to limit what trade we can do with them. Once again, this is a power that Congress gave itself, oversight in trade treaties. Another example is the Intelligence Oversight Act of 1980. The House and Senate oversight of intelligence activities requires the president to notify the Congress about covert actions that is linked to the Gang of Eight that I mentioned on an earlier slide. The Freedom Support Act of 1992 targeting former Soviet states in foreign aid and democratization, and can and did target specific nation states for their political ties and activities that were unpopular or were seen to be unpopular in Congress. This is just a few examples, and these aren't necessarily the most well-known. Probably will bring up others like the embargo of Cuba when we talk about economic statecraft in a later chapter. But we see here consistent patterns where Congress uses its lawmaking power when they feel that they don't have enough influence in foreign policy or want more influence in foreign policy. They use their constitutional lawmaking power to give themselves that say, to try to enhance their influence and enhance their power over policies and over the executive branch.